All right, y'all. Let's talk about Trump, travel bans, and the Supreme Court. That was very dramatic, but I don't have any follow-up. Okay, so there's some news. I guess it'd be yesterday now, that the Supreme Court has lifted the temporary injunctions on the travel ban issued by Trump, the most recent one. This is the third travel ban by executive order issued by Trump. The first two were interfered with by district courts. And the Supreme Court recently dismissed those cases as they are now moot, as the orders would have expired had the injunctions not been in place to allow them to, or had the injunctions not been in place and allowed the orders to take effect, they would have expired anyway. So Trump has issued a third executive order a while back. It was struck down by a federal judge in Hawaii, and a temporary injunction was placed during appeal. So the temporary injunctions, if you don't know, are where a court will recognize that a party is likely going to appeal, specifically in this case the government is going to appeal the lower court decision to the appeals court, and then ostensibly to the Supreme Court if necessary, and they put an injunction upon the order to prevent the executive branch from implementing the order until we get a final decision from the court, one way or the other. So then these injunctions are basically, they have to make a case that they're likely to succeed on the merits to uphold the injunction. So when the Supreme Court strikes down the injunction, it makes a statement. Now, caution here, the Supreme Court issued two very short statements about this. One from Chief Justice John Roberts, one from Justice Anthony Kennedy, both of which received petitions to remove the injunction. And both of them said they're like one-page documents. I'm not going to read through them. They're very boring. And they don't really have a lot of info. They basically just said that they're not upholding the injunctions. The orders are to be implemented as written. They also acknowledge that the Ninth and Fourth Circuit Courts of Appeals will be hearing the cases and have chosen an expedited hearing process. And the Supreme Court gave a subtle nod to the appeals courts to move those cases along and render their decisions very quickly. They're recognizing here that the president is issuing these executive orders, and they're for a limited period of time. And so what they don't want to do is have these injunctions keep coming through and thwarting the will of the president if they're constitutional, and then having the court process delay out through the injunction the execution of the order before the court has a chance to rule on if the order is valid or not. So the orders have changed a little bit since they were first implemented. If you remember or don't, who does? They initially contained 7 specifically primarily Muslim countries, and the courts found that to be a no-no. The courts decided that this was, these are lower courts, right? Decided that this was a specific Muslim ban, despite the fact that some of the largest population Muslim states are not included on it. So what they're doing is they're taking some campaign language used by President Trump to state that he wanted to slow or halt Muslim immigration into this country. And I think that's taken a little beyond the intention of the words. But I'm not the president, and a lot of people may disagree with that, and that's fine. That's fine, right? So this is actually kind of the issue that we get to with this particular case in court, is that the president made some statements on the campaign trail, and the court is introducing those statements as evidence, running contradictory to the plain text of the order. And that's a problem, right? Because what they're doing is they're taking political speech, which is protected by the First Amendment. Yes, even if you're a candidate for president, you have the freedom of speech, and political speech is some of the strongest protected speech. And in fact, the Supreme Court has addressed the use of campaign speech by politicians, trying to distinguish what's policy versus something called puffery, where they're pandering to their base or trying to attract new voters. And the rule of thumb really with this stuff is you go by the plain language of the legal act that's taken place. And so if we take any read of the executive orders issued by Trump and we take their plain language, meaning the very effects of the law that go into place, we can see that this is not a Muslim ban. The countries that are banned are primarily Muslim countries, but they are not the largest Muslim countries, and in no way does this thing seek to ban all Muslim applicants or entrants. Just specific ones that the president has determined may be dangerous, right? So the first question that the court has to address, and has not sufficiently addressed, is where does the president get the authority to do this, right? Like, the president is issuing an executive order. Why do they think they can do that? And it comes from a couple places, really. Let's see where to begin. Let's start with the law. This is a law passed by Congress quite a long time ago. This is the Immigration Naturalization Act. Basically been on the books since 1952. Or 57, I don't know, 50s, who cares, long time ago. And then the real trick here is actually specifically, it's 8 United States Code, section 1182, parentheses, F. And this is called the suspension of entry or imposition of restrictions by president. So, briefly, this is one short paragraph, bear with me. Whenever the president finds that the entry of any aliens or any class of aliens into the United States would be detrimental to the interests of the United States, he may by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. Whenever the Attorney General finds that a commercial airline has failed to comply with the regulations of the Attorney General relating to the requirements of airlines for the detection of fraudulent documents used by passengers traveling to the United States, including the training of personnel in such detection, the Attorney General may suspend the entry of some or all aliens transported to the United States by such airline. That is a huge grant of power by Congress. So, taking a step back, Congress has the constitutional power over immigration and visas, right? Like, they have the authority to determine how visas are issued, how immigration and naturalization occurs, and the laws which happen around that. Through the Immigration Naturalization Act, they gave a lot of power to the executive branch to go ahead and execute this stuff, right? They created, over the years, have created several departments through the Secretary of State's office, ICE, Immigration and Customs Enforcement, the Department of Homeland Security. We've got USCIS, so United States Customs and Immigration Services. These are all departments that have been created through the Immigration Naturalization Act and amendments that have gone through the years to that act. Right, Department of Homeland Security was created after 9/11, right, partly through the Patriot Act and the consolidation of some of the branches of the different intelligence branches, right? So Congress has given the president power. And that's not to say that the president has no power in this realm anyway. The president has the entire executive authority, which encompasses basically all of foreign relations. And to understand what that kind of looks like, what it's called, there's a case from the 30s, 1936, which is, I think, right? Should be 1936, which is Curtis Wright. Curtis Wright. And the details of Curtis Wright, probably not super important. Basically, it's a shipping company, Curtis Wright Shipping, and there's a dispute. This isn't important. What is important is a specific phrase from the opinion stating that the President of the United States is the sole organ in foreign relations and the sole organ in defense. So what they're doing, they're actually citing this old speech by John Marshall, who was the first Chief Justice of the United States. But that's not important either. I'm tangenting here. Sorry. Let's get back to this. What they state in this case is that basically the president is the sole entity which deals with foreign relations and with national security. Now, there's some debate over what exactly sole organ means, but let's just leave it at this for now. The president has immense power and immense leeway in both of these things, right? The heads of state can meet together and make agreements, and they can make them outside of Congress. They're called executive agreements. They have the same binding power of a treaty, but they don't require any congressional input. That's because the president is who manages the relationship with other heads of state. This is how it's been done for hundreds of years, going back to monarchies. The executive is who you deal with, because you can't bring hundreds of Congress people into a room with one head of another state. It's very awkward. You've got a bunch of differing opinions. The president is the unified body representing the entire nation. And that's really important to have. So you've got this sole organ of foreign relations, and you've also got the sole organ of national defense, right? The president is commander-in-chief of the armed forces, and he has a duty, not just the power, but the duty to faithfully execute the laws and protect the citizens of the United States from enemies, from both foreign and domestic, and the Constitution of the United States, right? He's supposed to defend the Constitution from domestic enemies, foreign enemies, any enemies that might be out there, and he has a massive amount of power to do this, right? We give nuclear codes to the president, and this is the only guy that makes the call if we fire missiles that wipe out an entire continent. If we have to. I mean, in theory, the entire world. It all rests in the hands of one guy. Currently, a guy named Trump, who a bunch of people are not happy about having that power. They're a little nervous. But since we dropped bombs on Hiroshima and Nagasaki, we've had the power of nuclear destruction put in the hands of one person charged with the defense of the entire nation, because when it comes to having a couple minutes with maybe a missile or a bomber incoming from another country to drop a nuke on us, if they're, say, attacking the White House, if they're, who knows where they're attacking, when you've got just a couple minutes to respond, you don't have time for debate. You have one guy tasked with that entire decision. So that's what the sole organ doctrine has kind of boiled down to throughout the years. Now, when you combine the sole organ doctrine with this grant of power from Congress, you combine two things. You combine the inherent power of the president, the inherent role of the executive under the Constitution in dealing with foreign nations and with providing for national defense. You combine that inherent power with the statutory power granted from Congress, where they have delegated some of their authority over the immigration process to the executive branch. And when you combine that, you have this juggernaut of power that really shouldn't be interfered with by the courts except in the most dire circumstances. And another history lesson for you. This is actually kind of codified in a very important decision from 1952. This is Youngstown Sheet and Tube Company versus Sawyer. The background of this is it's during the Korean War, and there's the impending strike of steel workers nationwide. Not a good thing to have during a war, right? Because our factories, our steel factories, need to be producing equipment for our soldiers. They need to be building tanks. They need to be building airplanes. They need to be building guns, bullets, other munitions. Like, we need steel, and we need steel happening constantly. So President Truman sees this strike coming. They've been trying to negotiate with the labor authorities of the steel mills. They're not getting anywhere. So Truman says, we're going to nationalize the steel mills. Yeah, yeah, I know. Freedom and all that. Truman says, too bad, we're nationalizing these steel mills. We can't afford to let them go down. We can't be held hostage by a bunch of union cronies going on strike. Like, that's not going to happen. Supreme Court ends up saying, no, not okay, right? You can't just nationalize industries because it's inconvenient for you during wartime. You can't do that. But that's not what's really the meat of the case. The meat of the case for our purposes, actually comes in a concurring opinion from Justice Jackson. And this is the Jackson test of executive power, and where it it's an informal test, and it's a guide for the courts to determine, maybe where they should interdict and where they shouldn't. And basically, you take the power of the president, or the power that the president is going to attempt to execute in this instance. And then you combine that or contrast that with the will of Congress and how they've expressed that will. And then you come up with a result of where you fall on the table. So we talked about this executive order, right? This executive order is granted under 8 U.S.C. 1182, parenthetical F. I read that specific language. And that's the language Trump uses in the executive order. He cites to it specifically with his authority to do this, right? Given to him by Congress. So he's also using his inherent presidential powers of defense and acting as the sole organ of foreign relations. Because, if you say you're not going to accept immigrants of any kind from a particular country, that has a foreign relations impact, right? If we told Mexico tomorrow, sorry, we're not going to take illegal or legal immigrants from you, the people of Mexico, the president of Mexico, would maybe take issue with that. So we can't just, we can't just determine these things in a vacuum. We have to understand that there's an impact there. So when the president is banning specific countries from entry into the United States, he's acting on that executive authority of foreign relation. So I'm not going to read through the whole test, but I do want to read just one specific section from Youngstown Sheet and Tube. Oh, excuse me. So here it is. When the president acts pursuant to an express or implied authorization of Congress, his authority is at its maximum, for it includes all that he possesses in his own right, plus all that Congress can delegate. In these circumstances, and in these only, may he be said, for what it may be worth, to personify the federal sovereignty. I think that's worth a lot. If his act is held unconstitutional under these circumstances, it usually means that the federal government, as an undivided whole, lacks power. A seizure executed by the president pursuant to an act of Congress would be supported by the strongest of presumptions and the widest latitude of judicial interpretation, and the burden of persuasion would rest heavily upon any who might attack it. This is where President Trump sits with these executive orders. He's granted the order. He has the express mandate from Congress. And I mean, listen to the language. Whenever the president finds that the entry of any aliens or any class of aliens in the United States would be detrimental, he may by proclamation and for any such period he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose any restrictions he may deem appropriate. Like, this is the broadest possible authority. It's entirely in your court, Mr. President, when you determine that things are bad. And here's the deal. If the president is over-exercising this power, Congress can change the law. That's the check. That's the check. The court is not the proper check here. Congress can change the law. But even if Congress determines that they're going to change the law and override the actions of the president still has the authority and duty to protect the United States in the time between his executive order and the new mandate from Congress, right? That's what this section is designed to do, to provide the maximum amount of authority for the president to protect the nation. So for a court, especially a district court judge, to override not only the will of the president, but the will of Congress at the same time, I mean, it's kind of stunning that we allow this in our system. And I'm probably going to do some videos on judicial authority. I talked about this a little bit in Marbury versus Madison, if you want to check that out. But the idea that we allow this to happen, it's very important to remember that we're allowing this. We're allowing the justices to have this. Presidents have challenged justices in the past. The presidents tend to win when they want to. Executive authority is broad because we've got an elected guy. And when he's backed up by a bunch of other elected dummies in Congress, like, it's hard to argue with that from one judge, especially in this case where that judge was appointed by his predecessor and political opponent. There's some questions about the neutrality of the judge in this case. So, long story short, not really, this is a long story and it's going to keep getting longer. This is going to the Supreme Court at some point. And I think any honest interpretation of the Supreme Court, they're going to look at Youngstown Sheet and Tube. They're going to look at Curtis Wright shipping. They're going to look at the statute 1182 parenthetical F, and they're going to look at the inherent power of the president. And the Supreme Court is going to really have to determine if they want to risk impeding on First Amendment speech, protected speech on the campaign trail, by applying that speech in a way broader scope than what's laid out in the executive order. And they're going to have to determine that that speech overrides the legal effect of this order. I think the Supreme Court is going to have a very hard time doing this. I think they're going to have a very hard time doing this, partially because they're a pretty they're a majority conservative court. But even so, like, lifting the injunction gives us an indication that they don't believe it is necessarily going to succeed. For what it's worth, Ginsburg and Sotomayor have stated that they would have left the injunction in place. And we don't know why they would have left the injunction in place. They may have just determined that since it's going to be fast-tracked through the appeals courts and then presumably fast-tracked to the Supreme Court, that the injunction wouldn't be too damaging. But, they were overridden by the other 7 justices, including Breyer and Kagan, which is saying something. And Kennedy, too. Kennedy is the type of guy who, if a conservative is going to flip on a matter of immigration, for example, Kennedy's the kind of guy who's going to go with the person who's weakest in a scenario a lot of time. He's gonna root for the underdog, and it's hard to imagine more of an underdog than an undocumented refugee, or someone who's undocumented fleeing a bad situation in a country that we've determined to be hostile, right? So Kennedy's gonna look for that sort of thing. But even he's one of the people who granted the lifting of the injunctions. So I was asked to kind of talk about where maybe this has been done before. And this has been done not in this way. Trump's use of it is novel, okay? That's important to remember. But he's not the first president to cite to this specific section in an executive order. Not at all, actually. We've got Reagan, we've got Bush, and we've got Clinton, and we've got Obama. All of them have cited to this order. Now, most of those citations are involving immigrants coming from the high seas, coming from outside U.S. territorial waters. The Coast Guard is granted the authority to kind of go through, check out these ships, see who's coming in, if necessary, send them back. This starts with Reagan. This continues with both Bushes, and then Obama also gets in there with his executive order. But his executive orders are a little different. His executive orders are, well, I'll read you the titles. I'm not going to read the whole text, but suspension of entry of aliens subject to United Nations Security Council travel bans and International Emergency and Economic Power Act sanctions. And then his other one is suspensions of entry as immigrants and non-immigrants of persons who participate in serious human rights and humanitarian law violations and other abuses. So he does not go through the same process that Trump does of laying out these specific countries that are considered risks, right? He doesn't do that. Instead, he leaves up the classification of people banned to the United Nations Security Council travel bans. And remember that, right? Remember that the United Nations Security Council has implemented travel bans and determined certain countries or certain classes of people within countries that shouldn't be allowed to travel to other nations. And that so did Barack Obama. This was I don't know if these were challenged by the court, but they certainly were not overturned by the court as far as I can tell. These and he didn't do this by executive order. That is a slight difference. Sorry. Obama did this by proclamation, which is the same thing as an executive order. In form and function, it's the same thing, but it's not an executive order. So they don't get as much publicity. They don't get tacked against your score of who issued the most executive orders within their first 90 days of presidency, or whatever metric you want to go with. But know that a presidential proclamation, carries the force of law in the same way that an executive order does, and is subject to repeal by a successive president. Oh, excuse me. Gotta stop recording in the middle of the night, right? Subject to repeal by a successive president at their whimsy, right? Trump could undo these things if he wanted to. But, what I want to get at here is that every president since Reagan has used this section to justify the removal or the exclusion of certain categories of aliens. Now, granted, Reagan's was people coming in on the high seas. So was Bush Sr. And then, except Bush Sr., he kind of narrowed it down a little bit. And he said specifically mass immigration from the Caribbean. I think that was Bush Sr. I better double check real quick. Before I, say something wrong. Hold on just a second. Very professional. Oh no, his was just his was just by sea. It was Bush Jr. that was specifically looking at undocumented aliens interdicted or intercepted in the Caribbean region. So So Bush Sr. has the high seas, similar to Reagan. Bush Jr. Has a more narrowly focused one on the Caribbean region. And this gives us a little insight, right? It's possible that they had specific people in mind who were potentially gathering to float in from the Caribbean. You've got Cuba in the Caribbean region. We've got potentially unfriendly people who might go through Cuba and then try and enter the United States through Florida by taking a short boat ride. Okay? It's not necessarily Cuban people. It could be any number of people. This is not a highly publicized executive order, so I tried to find a news story about who specifically Bush Jr. was talking about, and I wasn't able to find one. But we can infer that with the specificity of saying in the Caribbean region, that they've got a certain group of people in mind, and they may not have had any news about it because it may have been national security interests, something like that. But in any case, we've had every president since Reagan going ahead and using this to determine that groups of people, either in certain places, in certain situations, potentially certain ethnic groups or religious groups. If we look at Obama's bans, it's subject to whatever the United Nations Security Council determines. So we can certainly classify nations and group and by extension, ethnic populations of those nations in the bans of all of these presidents. Like, that's a possibility that it has happened. So what Trump's doing is unique in form in labeling specific countries, but it's not necessarily unique in function, and we can infer that these other presidents had specific people in mind. And we actually have a court case on the use of this subject. And I want to read just like a paragraph again, maybe a couple paragraphs from this court case to emphasize what courts look at. Now, this is a district court ruling. It was not overturned by an appeals court. It did not go up to the Supreme Court. So this was district court. This is 1985. So this would have been Ronald Reagan's ban. And this is the Haitian Refugee Center Incorporated versus Gracie. So I'm going to read from this section from the court on the president's constitutional and statutory authority to suspend the entry of illegal aliens on the high seas. Okay. The president's power to interdict illegal aliens on the high seas derives from statutory and constitutional sources. Congress granted statutory in 8 U.S.C. 1182F and 1185A1, which provide in F. We've already read this. And then A1. I'm not going to read A1. It's not important. These provisions make it clear that Congress has allowed the executive branch to exercise its broad discretion regarding alien immigration, citing Matthews v. Diaz. It is particularly appropriate for Congress to give the president a high degree of flexibility where the exclusion of aliens directly implicates the sovereignty of our nation and is interwoven with foreign relations, citing Matthews v. Diaz again, Zimmel versus Rusk, and Knopf versus Shaughnessy, something Irish. Congress has made clear its approval of the interdiction program through the budget process and providing funding for the program in a recent Senate report accompanying Senate Bill 2852, blah, 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 blah. It's not important. Congress has also specified that foreign aid under the Foreign Assistance Act. Thus, the president's action has received explicit support from Congress. The statutory authority for high seas interdiction is beyond doubt in this case, where the president and Congress so clearly concur. Haig versus Agee. So, this is what is going to look... This is what the statutory layout is going to look like when the court looks at this. Although, we may see some... We may see some more recent cases. Who knows? This goes on a little bit. In addition to statutory authority, the president has implied constitutional power under Article 2 of the Constitution to suspend entry of certain groups of aliens. The Chinese exclusion case of 1889, as the Supreme Court stated in Knopf versus Shaughnessy, in language applicable here. There is no question of inappropriate delegation of legislative power involved here. The exclusion of aliens is a fundamental act of sovereignty. The right to do so stems not alone from legislative power, but is inherent in the executive power to control the foreign affairs of our nation. United States versus Curtis Wright Export Corp. Yeah. And Fong Yu Ting versus United States. When Congress prescribes a procedure concerning the admissibility of aliens, it is not dealing alone with the legislative power, it is implementing an inherent executive power. This is, here we go. Even if there is no express statute for the president to execute, he may act to protect threatened American citizens or property, in R.E. Nagel. Thus, the president clearly has inherent authority to act to protect the United States from harmful, illegal immigration. This inherent power is closely related to the president's undisputed exclusive power to act, quote, as a sole organ of federal government in field of international relations. United States versus Curtis Wright. It is pertinent to observe that any policy toward aliens is vitally and intricately interwoven with contemporaneous policies in regard to the conduct of foreign relations. Harisiades versus Shaughnessy. In sum, you can skip to just this point, I guess. The president's power to suspend entry of illegal aliens from the high seas by interdiction has a clear constitutional basis. Now, if we're making an argument against this, right, against this case specifically, this is the authority to suspend specifically illegal aliens. So you could make the argument, but Trump is trying to suspend a broader category, not just illegal aliens, but also legal aliens, legal immigrants, and non-immigrants who want to come to this country on visas. Student visas, work visas, whatever. But if you go back, again, the language of Section 1182F covers both illegal and legal aliens, immigrant and non-immigrant aliens. It gives the president the broadest authority possible. I'm honestly stunned why this has gone on this long, why this wasn't immediately brought to the Supreme Court for the first order. I mean, this should not have been blocked by any district court, no matter what Trump said on the campaign trail, because even if he said, let's ban all Muslims because Muslims are a danger to the country, and even if he decided to go ahead and ban all Muslim immigrants, all of them, he can do it. And if Congress doesn't like it, they need to amend the law. They need to amend the law. The Justice Department, or the Judicial Department, judicial branch, is not the place for this discussion. We grant very few exclusive powers to the president, but, I mean, national defense, if there is one, it's defense. And it's defense, foreign and domestic. This is going to include any sort of importation or immigration policies. I'm sorry, you don't have to agree with the wisdom of the policy. I have lots of questions about the wisdom of Trump's travel bans. Now, I'm not privy to all the national security information that Trump has. I'm not privy to any sort of security clearance documents. All I've got is my general feelings on what's effective and what's not, what kind of risk our refugee populations pose, and I have trouble finding the same risk that our refugee populations or our asylee populations pose to some of the European countries which have had people walking in, because it's a lot harder to get to the United States as a refugee. You don't get to just walk across a border. You have to cross an ocean one way or the other, unless you're coming from South or Central America or from Canada. And everyone, in all honesty, should flee Canada, right? But unless you're coming from North or South, refugees and asylees tend to spend a long time in camps. They have a pretty intense process for vetting, and they don't necessarily get to pick where they go. So I don't know if this is the wisest choice. But what I do have a strong degree of confidence in is that this is within the president's purview and power, both from a constitutional standpoint and from a statutory standpoint. And I think once this thing gets to the Supreme Court, Trump prevails. I hate to put a guarantee on anything, but I think we've got a really, really high likelihood that he's going to prevail. So whether you like that or not, sorry, I think that's going to happen. Anyway, just a brief exposition here. The courts are playing a dangerous game. And I know the courts is such a broad term because we have district courts all over the place and individual judges at every level that don't agree with the Hawaii guy, right? Or the California guy or the Washington guy or whoever it may be. We've got a lot of independent actors wielding massive amounts of power. And again, I will reiterate, because we've let them. I think the courts are playing a dangerous game by allowing this to happen, because when you have voted politicians like Trump, like Congress, when you have these elected officials, and you override the will of the elected officials time and time again, you always run the risk that you undermine the judiciary's neutrality, that you undermine the judiciary's authority. Because, for example, we let the judiciary make these proclamations. Trump just goes along with it. But if Trump were to push back, if Trump were to just issue order after order after order, what would the judiciary do? Or if Trump simply said to his Secretary of State, ignore the order. We have an army. And if that judge continues to issue injunctions undermining national security, at what point does the president have the judge arrested? And I'm not saying this is the right thing. I think that would be a very bad thing, right? But that's the extreme case. But when the judiciary, which has no guns, comes up against the executive, which has an army, and which has the FBI, and which has the CIA, and which has a massive amount of police and military authority, when the judiciary rubs up against that, all they've got is the inherent trust of the people that the courts are neutral. But when the courts stop being neutral, and people don't like that someone appointed for life might have this power over the man that they just elected to keep them safe, we run a real risk. And we haven't had presidents really challenge that authority in recent times. I think I talked about this in Marbury versus Madison, but FDR challenged the authority. He won. The court bent. Andrew Jackson challenged the authority. He won. The court has no guns. What are they going to do to enforce the order? To enforce their order? The president has an army to enforce his. So, anyway, I hope these kind of conversations are at least a little bit historical. Maybe give you some stuff you might be interested in reading. Summary of the cases: we've got Curtis v. Wright, which is the sole organ doctrine. And if you Google sole organ doctrine, you can find papers many pages too long discussing it, and they're kind of interesting. You may be interested in reading that. And I think our generation, whatever that means, you don't know necessarily how old I am, but people older and younger than me, the people living right now, these generations, could probably use a dose of understanding on the sole organ doctrine, because we have a neutered concept of the executive. But the executive has a lot more power than we've seen. There was a lot of fuss about Obama expanding the power of the executive, but a lot of his power was properly executed, whether you like him or not. And he probably could have gone a lot farther on some of these things. We just haven't had presidents really challenge that. Trump is set up as a strongman president, and as the courts keep defying his policies, we could see that challenge come to light in a way it hasn't in, 70 years since FDR, really. So, anyway, sorry. Curtis v. Wright is the sole organ doctrine. Very interesting. Youngstown Sheet and Tube is an interesting case because it looks at this time when we're fighting communism in Korea, right? And the president thinks that the best action is to nationalize a business. Like, we're fighting communism in Korea. We're in a Cold War with Russia. We just fought fascism in Germany. Truman is the guy who dropped the bomb on the monarchy of Japan. And then he goes and attempts to nationalize the entire steel industry, huge industry in the 50s as well. American manufacturing is at its height in war, in wartime and post-war time, and he just does it. He does the one thing that we're not supposed to do. So that's an interesting kind of quirk of history that we run into. And Truman's a pragmatist, right? Like that's how he's the everyman. He's not this polished politician guy. He's like, we got to get it done, buddy. So that's a really interesting sort of thing. The other case I mentioned is the Haitian Refugee Center, but really that's just to kind of look at a case that doesn't involve Trump, that involves this 1182 parenthetical F of the INA. But yeah, if you guys have any questions, criticisms, problems with how dirty my room is or stupid hats or whatever, please drop them in the comments. Check out the Patreon page, patreon.com/lawsplaining. I do audio uploads of all of these right after the video uploads. So if you don't want to sit and stare at my beautiful face for a long time, you can actually just download the audio and listen. But you have to put up with the pauses, and they make even less sense if you can't see me yawning or whining or whatever I'm doing. So hope you guys have a good night. Any questions, drop them in the comments. I'll try and address them. If you have specific cases, drop them in the comments as well, and we can go through them. I will tell you my next video will likely be on the Michael Flynn and George Papadopoulos guilty pleas, which kind of go hand in hand, and we're going to talk about what those look like, and we'll go through the pleas a little bit. So thanks for watching, guys. I'll see you around. Sorry I can't make a video under 10 hours long. Deal with it.